The Kingstone, the dominant characteristic of the British Constitution, is the doctrine of sovereignty or supremacy of Parliament. This means that the Parliament has the right to make or unmake any law, whatever, that it can legislate on any topic whatsoever, which in the judgment of Parliament is a fit subject for legislation. That no person or body in Britain has a right to override or set aside a law of the Parliament, that the courts have no jurisdiction to declare an act of the Parliament void, ultra vires, or unconstitutional, and it is not legally bound by any mandate. The British Constitution is not written, and there is nothing like fundamental law of the country. Therefore, the power of the Parliament to legislate is legally unrestricted, and it can change even the constitutional principle by the same ordinary process as it enacts an ordinary law. Politically, however, the Britain has a responsible government with an elected House of Commons which reflect contemporary public opinion, social morality, or consciousness. Parliament does not therefore ordinarily do anything which a large number of people oppose. In this regard, Jennings observes the Parliament passes many laws which many people do not want, but it never passes any law which any substantial section of the population violently dislikes. But from a legal and not political point of view, there is no fetter or restraint on the British Parliament to make any law. Whenever Parliament enacts a law, is law, and its validity is not subject to any higher principles or morality, national or international law. Britain has no doctrine of unconstitutionality of parliamentary legislation, and a law enacted by the Parliament cannot be questioned or challenged in a court on any ground. The function of the courts is primarily to interpret the law enacted by Parliament and apply it to the factual situations coming before them for adjudication. The courts are not to scrutinize a law with reference to any fundamental norm, although in the process of statutory interpretation, the courts do bring in certain concepts of their own and interpret the law accordingly. When the courts are faced with several alternative interpretations of a statute, they would adopt the view which appears to them to be fair and just, and it may be that at times the judicially adopted alternative may not be in accord with what Parliament wanted to enact. Therefore, while the courts do not enjoy the power to declare an act of the Parliament to be invalid, they certainly have the power to interpret the same.